Okay, so you just received a bad decision from the VA on your claim and you want to appeal to the Board of Veterans Appeals. What do you do now? And just to be clear, in this video, I'm only going to be talking about post-AMA appeals. If you're not sure what that is, please go check out a previous video I did on how to tell if your claim is in the old system or the new system. When you're thinking about appealing your decision to the board, first you have to make sure that you can appeal your decision to the board. This means you have to have a decision from an initial claim, a request for an increase, a higher level review, or a supplemental claim. Any one of those types of decisions you can appeal to the board. Now, of course, when you appeal, you have to use the right form, which is VA Form 10182, and you have to file this form within 1 year of the decision that you're trying to appeal. Now, the VA titled this form Decision Review Request Board Appeal Notice of Disagreement. It kind of feels like they wanted to call it 3 different things, couldn't make up their mind, and just went with all of them. In part 2 of this form is where you check a box letting the VA know which appeal lane you want to use. There are 3 appeal lanes: the direct review, the evidence submission, and the hearing. Now, which lane you use depends on what's going on with your claim and, unfortunately, how long you want to wait. In the direct review lane, you will not get a hearing before a veterans law judge, and you cannot submit any new evidence. You're stuck with whatever was in your file on the date the decision that you are trying to appeal was made. That's it. But you can, and you absolutely should, submit a written argument with your appeal. Now, you can submit that argument at any point up until the board decides your appeal, but I think you should submit it right away with the appeal. Now, your argument, again, is not new evidence. That is just you explaining in great detail why the VA messed up your claim. When do I like to use this option? Well, first of all, you have to have a claim file that is complete. In other words, that there's just no more evidence that we need, and the VA can absolutely grant this claim with just what's in the file. The second thing I like to consider here is whether the problem with the claim, or rather the thing that the VA has messed up, is a legal issue. And the more tricky that issue is, the more likely I'm going to take it straight to the board rather than mess around with a higher level review or something like that. In the evidence submission lane, you will also not get a hearing before a veterans law judge. However, in this lane, you can submit new evidence, but you have to do it within a specific window. The VA allows you to submit that evidence within 90 days after the VA gets your appeal. I should say after the board gets your appeal. Now, you should be on the ball and you should submit that evidence with your appeal, so it's all done at once. You don't have to worry about it. You can, and you also should, submit an argument using this option as well, again explaining why the VA got your claim wrong. Whether I think a veteran should use this lane depends a lot on, first of all, whether you've got new evidence that needs to be a part of your claim. But then it gets really tricky after that, because you've got to decide, does it make more sense to file a supplemental claim and keep this at the regional office a little bit longer, or if this is something that needs to go straight to the board? And that's really tricky, and it totally depends on the specific details of what's happening in your claim. In the hearing lane, you, of course, get a hearing before a veterans law judge, before the veterans law judge who will be deciding your claim. And that can be a really good thing. You can also add new evidence, but the window is a little bit weird or a little bit different. So your 90-day window to add evidence does not start until your hearing. So it runs from the hearing plus 90 days. And that's good because it gives you time to track down and find something that may have popped up in the middle of the hearing. When do I think veterans should use this lane? Well, I mean, first and foremost, if you want a hearing. If a veteran wants a hearing, you should go this lane and get a hearing. That's the overriding consideration for me. Anything I want to do from one of the other 2 lanes, I can do in a hearing lane just as well. Now, I, of course, will talk to a veteran about what I think the pros and cons are of the hearing lane and whether I think it makes sense in their specific set of circumstances. But that's the veteran's decision because it's the veteran's claim. Now let's talk about time frame, because that's another important consideration. And I'm getting this information from statistics posted by the Board of Veterans' Appeals, and I'll link to that in the description below. But as of right now, it is currently taking the Board of Veterans' Appeals 305 days to complete an appeal under the direct review lane. It's taking them 357 days to complete an appeal under the evidence submission lane. And it's taking 497 days to complete an appeal under the hearing lane. So when you're thinking about a hearing, you have to ask yourself, is the hearing worth the extra 150 to 200 days that it's probably going to take for the VA to decide your claim? If you found this video helpful, please give it a thumbs up. That will help other veterans find it. If you'd like me to help you with your VA claim, please reach out to me through my website, walshvetlaw.com. There's a link in the description below the video. Thanks for watching.